Hello everyone, welcome to StudyIQ IAS English. My name is Praveen Mishra, and in this video we shall be going ahead with the discussion of the very much discussed and debated Minerva Mills versus Union of India case 1980. So a case that often creates too many questions and confusions, but for which you might be not having the proper answer. So guys, stay tuned with the video. By the end of it, you shall be going ahead with the proper understanding of what actually was the case and why the Sikh Industries Nationalization Act of 1974 led to this one particular landmark judgment of the India. Right? So here we go. And you know it very well that we are going to start it with the MCQs. So these MCQs, they are all related to the topics that we are going to discuss. So starting with the MCQs will provide you a very strong base, a very strong frame of the whole topic. So let's start, guys, with the first ever question. So the Supreme Court in Minerva Mills reaffirmed that judicial review is a basic feature of the Indian Constitution. Statement 2, Parliament cannot convert India into a totalitarian state through any sort of constitutional amendments. And Statement 3, Article 31 capital C in its expanded form is unconstitutional. So which of the following are correct? Guys, remember the beginning MCQs, I shall be providing you with the answers, but we shall be having some more MCQs at the end of the discussion. And for that, answers shall come from your end into the comment section later on once you have done watching the whole video, right? So which of the following are correct with regard to this question? 1 and 2, 2 and 3, 1 and 3, or 1, 2 and 3, all of the above. So basically, judicial review is a basic feature of the Indian Constitution. Judiciary reaffirmed this. Statement 1 is correct. Statement 2, Parliament cannot convert India into a totalitarian state through any constitutional amendments. This is also something that was stated by Supreme Court. So this is also correct. Statement 3, Article 31 capital C is in its expanded form is unconstitutional. That is also what Supreme Court stated. So all the three statements are correct. So our correct answer will be D. That is 1, 2, and 3. Right? So stay tuned, guys. All of these things we shall be discussing in the rest of the minutes upcoming. Question number 2. The Minerva Mills decision redefined the scope of Parliament's amending power under Article 368. And which of the following statements best captures the court's position? So we have got four options. Option A, Parliament's amending power is unlimited but subject to ratification by half of the states. Option B, Parliament's amending power is constituent power that can even abrogate the basic structure. Option C, Parliament's amending power is limited. It cannot destroy the essential features of the Constitution. And option D, Parliament's amending power is co-equal to the Constituent Assembly's powers. So what do you think would be the correct answer? Well, yes, if you are analyzing it to be option C, you are absolutely correct. So yes, Parliament's amending power is limited and it literally cannot destroy the essential or basically the basic features of our Constitution, right? So this is what the judgments you just understood with regard to the Minerva Mills case. And now let's talk about the whole scenario. Where is Minerva Mills? First of all, what is Minerva Mills? A mill industry basically located in the beautiful state of Karnataka, which was a private textile manufacturing company producing silk garments. And over the period of time, it faced some huge financial losses and operational difficulties that made this one particular company a Sikh industrial unit. And the central government initiated an inquiry to assess its performance and viability. So it was an industry. See, India at that time was focusing more on socialism. So if an industry which was going continuously back to back in under operational difficulties or financial losses, obviously it was becoming difficult for the stakeholders, directors, or the owners of the company to provide the proper remuneration and salaries to the workers. That was ultimately impacting the national growth and development. Hence, as a result, in order to overcome all of these issues, during the 1970s, India formalized some legislations that were focusing more on socialism, but ultimately that disturbed the capitalist class. So as you can see the context, during the 1970s, India faced a wave of industrial sickness, especially in three industries, and they are the textile, the steel, as well as the engineering sectors. Literally many private industries were financially collapsing, leading to huge level of job losses, NPAs, that is non-performing assets, and economic instability. And guys, remember 1970s, the Cold War era is going on. We already had two traditional rivals with us at that time, Pakistan and China on the eastern and western borders, right? Now, in order to prevent such type of economic losses and instability, the central government used nationalization as a tool, taking over management of sick industries in public interest. And they had this power under Article 31 capital A inserted through the first Constitutional Amendment Act of 1951. And so they legislated. Here we are having the legislative reforms. So the Sikh Textile Undertakings Nationalization Act of 1974 came into being. That literally empowered the central government to acquire and take over all the Sikh textile mills. And there was only one single objective. And what was that? The very same. Protect the job loss, protect any kind of economic instability. So protection of workers, revive production, and safeguard the economy. This was the only agenda that was happening at that time. So for that sake, the central government, 1974, enacted the Sikh Industries or Sikh Textile Undertakings Nationalization Act. Okay. Now, what if these things was challenged in the Supreme Court or in the judiciary? You know it very well. The central government or the legislation at that time had a shield named as Ninth Schedule. So to protect these socialist legislations from any kind of judicial review, Parliament placed many such acts, including this Nationalization Act, into the Ninth Schedule of the Indian Constitution, that is technically through the aegis of Article 31 capital B. Once again inserted to the Constitution through the first Constitutional Amendment Act, right? And so as you can see, Parliament was using Article 31 capital B, the Ninth Schedule, as its shield from any kind of judicial review that can declare any law as invalid on the grounds of contradiction or the contravening elements with the fundamental rights. So they had inserted Article 31 capital C already through the 25th Amendment Act of 1971. That stated that if Parliament is enacting any one particular element or any type of a legislation that is just for the sake of giving the force of law to the rights or to the guarantee or to the directions issued under Articles 39 clause B and C, even if they are contravening with Article 14, 19 or 21, they can't be challenged in any court, right? So once again, using Article 31 capital A, 31 capital B and 31 capital C, the Sikh Textile Industries Nationalization Act of 1974 was placed. And so it happened. Minerva Mills, which was continuously registering losses on its ledger, on its balance sheet since couple of years, came into the eyes of the central government. And once again, going ahead with the socialism element, the government decided to nationalize this industry. So as you can see, the chain of events. So once again, the act was challenged in the court. As the owners of Minerva Mills, they stated, it's our industry, it's going in losses, no worries, we'll manage it. The Minerva Mills Limited, that is a textile company, was nationalized under this. And the owners challenged the constitutionality of the act, including Section 4 and 55 of the 42nd Constitutional Amendment Act. Okay, and then comes in the case. The government took over the mill, okay, through the act. And further, the company challenged this takeover, arguing that it violated their Articles 14 and 19. Specifically, the 42nd Amendment, okay, Sections 4 and Section 55, they were said to be unconstitutional. Further, as you can see, what is Section 4? So, it says, effectively meant Parliament could override fundamental rights in the name of directive principles. For the sake of implementation of directive principles, Parliament can override simply what? The fundamental rights. Next, as you can see, the constitutional provisions involved. So the government introduced Article 31 capital C, not just for the sake of implementation of Articles 39 clause B and C, but for all the other DPSPs. So it said, if a law implements any DPSP, it cannot be declared void or violating Articles 14 or 19. Not just 39 clause B and C, but any of the laws that are for the sake of implementation of any of the DPSPs would be protected, even if they are violating the fundamental rights. Okay. So as you can see, the Section 55 of the 42nd Amendment. So it stated that Article 368, no constitutional amendment could be questioned in court. Okay. So literally what? Any constitutional amendment is supreme from any kind of judicial review. And this was a direct challenge to the judicial review doctrine, which was also the basic structure that was propounded by judiciary in the Kesavananda Bharati case, right? So moving forward, as you can see here, issues before the court in the Minerva Mills case. Can Parliament through Article 31 capital C give unlimited precedence to DPSPs over fundamental rights? Statement 2, the problem 2. Can Parliament through Article 368 bar the courts from reviewing any kind of constitutional amendments? And statement 3, is the nationalization of Minerva Mills literally valid? And so here comes in the judgment. So the issue, once again, primacy of 31 capital C. What Supreme Court stated. Article 31 capital C will be valid only for the implementation of Article 39 clause B and C and not other fundamental rights. Then judicial review. Is it really the basic structure? And literally can constitution or literally can Parliament override judiciary from reviewing any constitutional amendments? So it was struck down. Section 55 of the 42nd Amendment Act was struck down. Parliament cannot make itself supreme. Judicial review is part of the basic structure and it will take place on each and every legislation. And finally, was the nationalization valid? So yes, nationalization was upheld. The takeover or the nationalization of Minerva Mills was valid as it aimed to revive the sick industry in the name of public interest. Right, guys? So the key doctrines were reinforced once again. This was introduced in the Kesavananda Bharati case, but it was reintroduced or reforced. Technically, what are they? The basic structure doctrine, the doctrine of harmonious construction, as well as the judicial review. Right, everyone? So this is it all with regard to the Minerva Mills case. I hope this is all clear. And there are some MCQs, and these are the MCQs to be answered by you all. So this is question number 1. Okay, I'm giving the citation. So as you can see, consider the following statements. Section 4 of the 42nd Amendment Act expanded Article 31 capital C to cover all the DPSPs. Statement 2, Section 55 of the 42nd Amendment Act made constitutional amendments non-justiciable as in beyond judicial review. Statement 3, both these sections were struck down by the Supreme Court in the Minerva Mills case. So which of the above statements are correct? So A, B, C, D, you'll have to let me know into the comment section. Then coming up, the question number 2, assertion and reasoning. Assertion, Minerva Mills case directly arose from challenges to the nationalization of textile industries. Reasoning, nationalization laws were placed under the 9th schedule to protect them from judicial review. So options once again, A, B, C, D. Let us know the correct answer into the comment section. Okay. Then we have got question number 3. The doctrine and the origin. Okay. So basic structure doctrine, was it Golaknath versus the state of Punjab? Limited amending power, Kesavananda Bharati versus the state of Kerala. Harmony between fundamental rights and DPSPs, Minerva Mills versus Union of India. So what is the correct matchup? Okay, so A, B, C, D, I've got 4 options again. Let us know. Please guys, provide the citation into the answers. Okay, that this is question number 1 answer, this is question number 2 answer, question number 3 answer. And if you have any doubt, please do mention your doubts into the comment section as well. And yes, if you are a serious aspirant targeting either 2027 or the 2028 year of examination, we have got for you our resolution plus batches. 1000 plus hours of live lectures will be given to you in these batches, along with the access to recorded lectures in case you miss those live lectures. Well, that's not enough, right? Let's talk about the reading material. 18, literally 18 sets of printed books would be sent to you at your doorstep. Okay. And apart from that, teachers' personal class notes will be shared with you at the end of the session. Every day in PDF format after every session. Furthermore, the very same subscription will provide you the prelims test series, 75 plus tests for prelims, 12 plus tests for mains, that is mains test series, and multiple mock interviews for your personality test, that is your UPSC CSA interview. So interview guidance program, mains test series, prelims test series, along with 1:1 mentorship program, everything covered under one single subscription. Guys, remember the batches are going to commence from 18th of November for 2027 as well as for 2028. Both the batches are commencing from the same date. And now here is the tip. Here is the trick. Here is the code. If you want to enroll with the cheapest price, with the maximum discount, so here is the promo code for you. If you apply this code PRV Live, okay, this code will provide you the maximum discount. Yes, you heard that correct. Maximum discount on your subscription. Right, everyone? So quickly enroll using this code PRV Live, whether for 27 or for 28. Promo code remains the same. Okay, and you will be enjoying the maximum discount on your subscription price, right? So PRV Live, remember the code. Okay, everyone, and please, before you leave, hit the subscribe button of our channel, StudyIQ IAS English, and never miss an update from it. And also, you can join me on my Telegram, that is here. The QR code, you can just scan and connect, or you can go on the search bar and type the channel name Praveen_StudyIQ. And you can also join me on my Instagram with the username Praveen Mishra_2107. Okay, guys, so thank you so much for watching. Once again, see you all soon in the very next session. Bye bye. Good day. Take care. Keep studying well. Jai Hind.